program today. This is the next in our series of compliance webinars. Today we're going to be talking about 42 CFR Part 2, or the federal regulations governing the confidentiality of substance use disorder records. My name is Kim Stenger. I'm the chair of Holland & Hart's Healthcare Group, and I will be discussing these issues with you today. As I mentioned, this is the latest in our compliance webinar series. Up on the screen, there's a list of programs that we have coming up. Our past programs are also available at our website. You can access those for free in case you have any interest in going back and listening to or re-listening to any of the compliance programs we've done in the past. Today, dealing with 42 CFR Part 2, I wanted to talk a little bit about an update concerning some of the recent amendments. We're going to talk then about application of 42 CFR Part 2, including to whom it applies and what kinds of records it applies to. Then we're going to talk about the confidentiality requirements, including those applicable to disclosures and redisclosures of Part 2 information, and close off by talking about some of the additional record-keeping requirements that are associated with it. This program is being recorded. If you would like to listen to it in the future, you're certainly welcome to access that at our website. In addition, if you have questions throughout the program, because it is recorded, we're not going to be taking questions during the program, but if you'd like to submit them using the chat feature or emailing me, I'll respond offline. You should have received a link with a bunch of written materials. If you did not receive those, you can contact ldsquyres@hollandhart.com. Just Laura Squires at our office, and she can make sure that she gets you those materials. Among others, I provided you with a copy of the CARES Act, Section 3221. That's the section from the CARES Act that amended the relevant statute dealing with the substance use disorder records. I've also given you a copy of the new regulations that issued in August concerning the regulations. In the copy of the materials that I provided to you, I highlighted those sections that were changed in August. So that may be a helpful resource if you're not familiar with what has actually changed. I've also given you a copy of the links to the revised regulations and the commentary that accompanied them, if you have any of those questions. Also, I've given you a series of fact sheets from SAMHSA, which are very helpful in understanding and applying Part 2, especially under the new rules as well as the current rules, which of course may change in the near future. When we're talking about the Part 2 laws, I wanted to touch base briefly to let you know that the 42 CFR Part 2 was actually enacted as a result of the statute in 42 U.S.C. 290 DD. That's the section that requires the confidentiality of substance use disorder program records. That was amended, that statute was amended by the CARES Act, Section 3221. Subsequent to that, we have the regulations that are found in 42 CFR Part 2. That's what we're going to be focusing at. But you also have to keep in the back of your mind, you've got to comply with the Hipaa privacy and security rules and other federal and state laws that may apply to your use or disclosure of the information. It's important that you remember that when it comes to applying all of these different laws that don't always mesh very well, that you've got to comply with the most restrictive law, whether that's a federal or state law. So to the extent that the law gives greater protection than 42 CFR Part 2 does, then you've got to comply with that more restrictive state law or federal law. To the extent, however, that the other law gives greater control to the patient, allows the patient to exercise their rights, then you've got to comply with that law. However, to the extent that you have a conflicting state law, or perhaps HIPAA would allow you to make disclosures that aren't otherwise allowed per 42 CFR Part 2, then you have to comply with 42 CFR Part 2. So you've got to make sure that you comply with the most restrictive law. And that's sometimes a bit of a challenge because the laws don't match up very well. One of the benefits of the new regulations is that they tried to match up 42 CFR Part 2 with HIPAA a little bit better. Didn't go as far as I would like, but we'll talk about that more in a minute. All right, from a big picture point of view, 42 CFR Part 2 governs the confidentiality of substance use disorder patient records. Its whole purpose was to encourage or not discourage persons from receiving treatment for substance use disorders by limiting the disclosure of the information relating to their treatment, so it couldn't get out there and be used against them in court cases or in employment or other matters. So in general, Part 2 programs, those that are covered by 42 CFR Part 2, may not disclose any information that would identify a person as having or having had or being referred to a substance use disorder treatment program unless the person provides a written consent or a different exception applies. It not only applies to the Part 2 programs, but it also applies to certain entities to whom the Part 2 program discloses the information. Those other entities, those downstream entities, may also have to comply with Part 2. As far as an update, Part 2 has really been subject to changes. So I think in 2017, they modified the regulations. They modified them again in 2018 or 2019. In 2020, as part of the CARES Act, that was the Coronavirus Stimulus Package, the Relief Act, they stuck in, I don't know exactly how it came to be, but they stuck in sections that further modified 42 CFR Part 2. Now, we'll talk about those as we go throughout this program. In addition, in August of 2020, SAMHSA also amended the 42 CFR Part 2 regulations so that they adopted more changes. Now, those changes that occurred in August to the regulations did not incorporate or address the additional changes that are going to be required by the CARES Act. So we're kind of in this limbo stage. We've got new regulations, but we've also got a statute that's going to require further regulations. These new regulations that are required by the CARES Act can't take effect until after March 27th, 2021. So we anticipate getting those new regulations sometime. It's not clear whether we're going to get those before March 27th, 2021 or not, but you need to make sure that you watch out for those. That CARES Act essentially requires, or it actually loosened up 42 CFR Part 2. It made it a little bit easier to comply with, among other things. It allows for disclosure of substance use disorder information for treatment, pain, or healthcare operations with consent. It had broadened up some of the consent requirements. It also imposed some of the, or incorporated some of the Hipaa issues into 42 CFR Part 2. We're going to talk about those as we move forward through the program today. In addition, as I mentioned, following the CARES Act, but not in response to the CARES Act, SAMHSA revised the 42 CFR Part 2 regulations. Those became effective on August 14th, 2020. Those are the copy of the regulations that I provided you today. As I mentioned, those new regulations do not address the CARES Act, and therefore we're still waiting for the guidance on the CARES Act. So make sure that you pay attention. It's entirely possible that a lot of the things we talk about today will be modified or changed within the next few weeks or months as we get those new regulations. All right, well, why do you need to comply with this? Well, because you can get hit up with significant penalties if you don't. Under the prior version of 42 CFR Part 2, it was actually made it a criminal matter. It was a crime if you disclose this information improperly. Part of the CARES Act, Section 3221, it modified that. It deleted the section that made it a crime. Instead, CARES Act Section 3221 incorporates the Hipaa penalties. So now you may be liable for Hipaa penalties if you violate 42 CFR Part 2. As you know, those Hipaa penalties have a tier structure, and the amount of the penalty depends upon your mens rea, the conduct that's involved. The penalties can range anywhere from approximately $120 up to $60,000 per violation. And each time you disclose a patient's record improperly, that for each one of those patients could be a separate violation. So those penalties can add up awfully quickly. If you are deemed to have acted with willful neglect, then at least under the Hipaa program, then you can be hit up with mandatory penalties of $12,000 to $60,000. If you act with willful neglect, but you did not correct it within 30 days, then it's a mandatory penalty that was of at least $60,000. We don't know exactly how this penalty structure is going to be applied to 42 CFR Part 2. Is it going to be exactly the same penalty structure? Is the mens rea element going to be a little bit different? We're going to have to wait to see how those regulations shake out to figure out exactly, okay, what is the penalty structure? About all we know right now that it's no longer a crime to disclose this information improperly, but you can get hit up with those civil penalties, and those civil penalties can be pretty exorbitant. In addition, as part of the CARES Act, you now have an affirmative obligation to report breaches of unsecured electronic health information under the 42 CFR Part 2, just like you would under Hipaa. So it incorporates the breach notification requirements. Again, we don't have the regulations yet. We don't know exactly how this is going to work for the SAMHSA regulations for 42 CFR Part 2. So we're going to have to watch for those regulations to figure out, okay, exactly how does that reporting requirement work? Does it follow the same requirements as HIPAA? Or who are you making the disclosure to? Is it to HHS? Do you have to do the electronic disclosure? Is it part of the disclosure that you would make under HIPAA, or what? An important question for these penalties is, well, what happens if you've got a SAMHSA violation? If you've got a 42 CFR Part 2 violation, then chances are you also have a HIPAA violation, because HIPAA generally incorporates more restrictive federal laws. So does that mean that you can get fined twice for the same violation? Again, we don't really know. There is also a possibility that that you could get hit up for private lawsuits for a violation of the 42 CFR Part 2. There, like HIPAA, there is no private cause of action expressly set forth, but it's possible the patient or a patient's attorney might be able to claim a common law privacy tort, or might use the Part 2 regulations as the basis for a negligence per se claim. The bottom line is you need to make sure that you understand what your requirements are and that you maintain the confidentiality of these records. So let's discuss who this applies to. Well, as I mentioned, 42 CFR Part 2 generally prohibits the use or disclosure of records without the patient's consent if, and there's two criteria here. The first, the record has to be an SUD record. We'll talk about that in a little bit later. Second, the record had to be created, obtained, or maintained by a federally assisted drug or alcohol abuse program. That's really the key that usually comes up. Are you, or is the entity from which you obtain these records, a federally assisted drug or alcohol abuse program, an SUD program? Well, what is an SUD? Well, it's the cluster of cognitive, behavioral, and psychological symptoms indicating that the patient continues using substance despite significant substance-related problems such as impaired control, social impairment, risky use tolerance, and withdrawal. So that's what a substance use disorder is. Well, what's a substance use program? Well, it has to be federally assisted first. It's not all programs, only those that are federally assisted. What does federally assisted mean? Well, that's pretty broad. It applies if you carried out your services under a license or authorization granted by the U.S. Department or agency, including participating in Medicare or being registered with a DEA registration, or if you are supported by funds provided by a U.S. Department or agency, including receiving Medicaid, receiving grants, receiving any kind of federal financial assistance. Also, if you're a tax-exempt entity, a 501c3, then that also triggers federal assistance and triggers your obligation. If it's conducted directly or by contract or otherwise by any department of agency of the United States, then that also pulls you into the federally assisted program. There's special rules for the VA or armed forces. So these rules would not apply if you are a purely private pay program. So if you're not getting any federal money whatsoever, no federal money is used to pay for any of your services, then 42 CFR Part 2 would not apply. You may still be subject to HIPAA, which incorporates a lot of the same types of requirements and now apparently incorporates the same penalties, but you wouldn't have to comply with 42 CFR Part 2. One of the examples that the SAMHSA gave is, let's say that you are providing services pursuant to an order from the court. The court is paying for those itself. It's not coming from federal money, then that would not necessarily trigger 42 CFR Part 2. Usually, if you're trying to figure out whether you are a federally assisted program, it's not a question of whether you're federally assisted, because most entities participating in the healthcare program in the United States are, because they're getting Medicare and Medicaid money or otherwise DEA certified. The question is whether or not you are a program. So here's where it really comes down to try and figure out whether or not you're covered. A program means that you are an individual or entity other than a general medical facility that holds itself out as providing and actually does provide SUD diagnosis, treatment, or referral, or you're an identified unit in a general medical facility that holds itself out as providing and provides SUD diagnosis, treatment, or referral for SUD services, or you are medical personnel in a general medical facility whose primary function is providing an SUD diagnosis, treatment, or referral, and who are identified as such providers. So for the definition of provider, it depends a little bit on whether or not you're part of a general medical facility or not. A general medical facility is basically just one of those facilities that provides lots of healthcare services, not just specific to SUD. So in the SAMHSA regulations or the commentary, they suggested it's entities like hospitals, trauma centers, FQHCs, maybe multi-specialty practices, things like that, where they provide a range of services. This chart is helpful in understanding whether or not you are a program. So these are the rules, okay? If you are an individual or entity that is not a general medical facility, then you are a Part 2 program if you receive federal assistance and you hold yourself out as providing SUD diagnosis, treatment, or referral for treatment, and you provide the SUD diagnosis, treatment, or referral for the treatment. So you hold yourself out as providing it and you provide it, okay? If you are part of a general medical facility like a hospital or FQHC or other multi-specialty practice or general practice that provides services other than just SUD, then the test depends on whether or not you're an identified unit or medical personnel or staff within that entity. If that general medical facility has an identified unit that holds itself out as providing SUD diagnosis, treatment, or referral for treatment of SUD conditions, and that identified unit provides that diagnosis, treatment, or referrals, then that unit is a program. Similarly, what about medical personnel? Well, those medical personnel within the general medical facility, if those medical personnel provide, their primary function is to provide SUD diagnosis, treatment, or referral for treatment, and they're identified as such by licensure or others, that they're identified as, hey, this person is an SUD provider, then that person, that physician, that mid-level or professional person could also be a Part 2 program. So you could have a situation where you've got an identified unit of a general medical facility that's a Part 2 program. In addition, or alternative, you could have specific individuals at that general medical facility that is deemed to be a Part 2 program. Now, for a lot of these, it depends on whether or not you're holding yourself out as a Part 2 program. What does that mean? Well, hold yourself out, according to the regulations, that's when you engage in any activity that would lead one to reasonably conclude that the individual or entity provides SUD diagnosis, treatment, or referral for treatment, for example, through advertising or marketing. In the SAMHSA FAQs that we provided to you, they have a helpful one at FAQ 10, and they explain that holding yourself out may include state licensing procedures. So if you have a special licensure in your state that allows you to provide SUD treatment and identifies you as an SUD treatment provider, or you advertise or post notices on the media or elsewhere that you provide SUD treatment, certifications in addiction medicine, listing in registries, internet statements, consultation activities for non-program practitioners. So you market yourself or make yourself available to provide SUD consultations for non-program practitioners. If the information presented to the patients or their families identifies you, or you, in those communications you hold yourself out as providing SUD treatment, then you are determined to hold yourself out as and maybe a program, thereby triggering the requirements applicable to your records. Well, what is not a Part 2 program? Well, just because you work in a hospital emergency department and somebody shows up with an OD and so you provide care for that particular person, that does not turn you into a Part 2 program. Similarly, primary care providers or other providers who prescribe controlled substances to treat substance use disorder, but who do not otherwise hold themselves out as providing SUD treatment. So it may be part of what they do as a general practitioner or whatever, but as long as they're not holding themselves out as or advertising themselves out as an SUD provider, then they are not considered to be a program and impacted by 42 CFR Part 2. When you're talking about the general medical facility, being having a Part 2 program does not make the entire general medical facility a Part 2 program. Instead, the Part 2 program limits only apply to that identified unit or the individuals who are Part 2 programs. That means the rest of the facility is not a Part 2 program, okay? That means the Part 2 limits only apply to that portion that is the Part 2 program, but the practical effect of that is that Part 2 program then has limits on its ability to share that information with the rest of the facility. We'll talk about that more a little bit later. Okay, that's who Part 2 applies to. Let's talk next about the what it applies to. Well, generally, Part 2 prohibits the use or disclosure of records without the patient consent if the record identifies the patient as having had, or is referred for a substance use disorder, even if the person doesn't have a substance use disorder, okay? So it's not only current, but it's if they've ever had it, or identifies them as ever having it, or they're referred for substance use disorder treatment or evaluation. That prohibition on disclosing that information applies even if the person seeking the information already has it or may obtain it elsewhere, kind of like Hipaa. Just the fact that, just because somebody already knows it doesn't mean that it's still not protected and doesn't allow you to go ahead and disclose it. It applies even if the information is sought by law enforcement or any other government agency. So you can't just turn it over even if it's the police. There are certain processes that have to take place before they can subpoena or obtain that information. And it applies even though the use or disclosure is for a civil, criminal, administrative, or legislative proceeding by any state, federal, or local authority. We'll talk more about that in a minute. Now, Part 2 applies to SUD records. Well, what are records? As part of the recent Part 2 amendments that SAMHSA promulgated in August, records are defined as any information, whether recorded or not. So it applies to even oral information, which is kind of interesting. You wouldn't think that an oral discussion is a record, but the definition specifically says any information, whether recorded or not, created, received, or acquired by a Part 2 program relating to a SUD patient, including, for example, their diagnosis, treatment, referral for treatment, billing, emails, voicemails, texts, photographs. It can be any information that's in paper, electronic, oral, or any other form or format. Now, the Part 2 amendments that they just did make a significant modification. They clarified that Part 2 records, it does include written information conveyed by a Part 2 provider to a non-Part 2 provider. So the oral information itself is protected. But if that non-Part 2 provider, like the treating practitioner, for example, then takes that oral information and records it in their own record, that non-Part 2 provider's own record does not become a Part 2 record, okay? Similarly, if the Part 2 program sends a written record to that non-Part 2 provider, like the primary care physician, if they send that Part 2 record, well, that Part 2 record is protected by Part 2, but if that receiving non-Part 2 provider, that primary care provider, for example, segregates that record and doesn't include it in their record, then that Part 2 provider, or that non-Part 2 provider, the treating physician, his own record of treatment does not become protected by Part 2. As long as they segregated the information or the record that they got from the Part 2 provider, then Part 2 does not extend to that provider's own records. That's a significant change. It limits the scope of Part 2 and allows more easily the communication with participating providers. Well, Part 2 records, it only applies to any information that's initially prepared by a Part 2 program that would identify the patient as having or having had an SUD, including records indicating the patient was diagnosed with, received, or was referred for SUD treatment. So it has to be identifiable. It has to be patient identifying information. If it's been completely de-identified, so it's not linked back to an individual, then it's no longer protected by Part 2. Identifying information could be name, address, social security number, photos, fingerprints, or similar information by which the identity of the patient can be determined. Now, the regulations specifically exclude certain types of information, particularly diagnosis made solely for the purpose of providing evidence for use by law enforcement. Well, that wasn't for treatment or diagnosis of the, or treatment for the patient, so that's not covered by Part 2. Or diagnosis of drug overdose or alcohol intoxication, which clearly shows that the individual does not have an SUD, then that's not covered by Part 2 either. Well, who are the entities that must maintain the confidentiality? Well, the prohibition against disclosure applies to certainly the Part 2 program. It also applies to entities having direct administrative control over the Part 2 program. So if you have a situation where for example, a general medical facility that has a Part 2 program within that facility, it would also apply to those with administrative control that are outside the program but who still control the program. It also applies to lawful holders of Part 2 information. These are entities that have received the Part 2 program appropriately. So they've received the information and or they've also received the required notice prohibiting redisclosure. So they've been put on notice that they have to comply with the Part 2 limitations. We'll talk more about that in just a minute. Now, as I mentioned, the new regulations modified the situations in which the Part 2 limitations would apply to non-Part 2 providers. So for example, if a Part 2 program is sharing Part 2 information with the treating physician who is not otherwise covered by Part 2. So the Part 2 provider generally may disclose Part 2 information to the non-Part 2 provider with the patient's consent. Generally have to have the patient's consent, even if it's for treatment. But that Part 2 does not apply to the non-Part 2 provider's own records, so the records that that non-Part 2 provider prepares, so long as they do not incorporate that Part 2 record, the actual physical record, into their own records that become part of that, the Part 2, the record that's prepared by that treating provider. So if, for example, we have a situation where a Part 2 program calls the treating provider, the provider calls the Part 2 program to get information about a patient that primary care physician is treating. They want information about the Part 2 program. Assuming that the Part 2 program has the patient's consent, they can disclose the information orally to that treating provider. That treating provider then can summarize that oral information into their own record, and Part 2 does not apply to that record, okay? Alternatively, it may be a situation where the Part 2 program sends a copy of its written record, or a written record from the Part 2 program to that treating provider. That Part 2 record itself is protected, but once it goes to that non-participating or non-Part 2 treating provider, so long as that treating provider segregates that Part 2 record and does not include it in his own record, then that provider's own record is not subject to Part 2. So it makes it easier to have those communications and protects that treating provider from suddenly all your other records. Well, that disclosure, that limit on disclosure applies even to responding to requests about a patient. So if you get a phone call asking whether or not a Part 2 patient, an SUD patient, is receiving services at your facility, you can't disclose that or answer that question in a way that would indicate that that patient is part of an SUD program. So you may not acknowledge the patient's presence if your facility is publicly identified as a place where SUD diagnosis, treatment, or referral for treatment is provided, unless the patient consents or there's an authorizing court order per Part 2. So you can't generally acknowledge that the patient is there if you are an SUD program, or everybody knows you're an SUD program, because if you identify the patient's there, then everybody's going to know that that patient's there for SUD treatment. So you couldn't acknowledge that unless you have the patient's consent. Now, you may acknowledge the person's presence in your facility if your facility is not publicly identified as only an SUD facility and the acknowledgement does not reveal the patient has an SUD. So let's say that you work for a hospital. The hospital provides a lot of different services, not just SUD. If somebody calls up and asks whether the patient is there, then as long as your facility is not identified as solely providing SUD and you do not disclose the patient's presence in a way that would indicate that that patient is receiving SUD treatment, then you may go ahead and disclose it in that case. If it's a situation where there could be a disclosure that the patient is receiving SUD, then any answer to a request for SUD records must be made in a way that will not affirmatively reveal that the patient has been or is being diagnosed or treated for an SUD. So for example, if you get a call from a treating provider and says, hey, we want you to send over all the records, you can't say, hey, that patient is receiving SUD treatment and therefore we can't send over the records unless you comply with Part 2, because you've now disclosed that that person is an SUD patient unless you have the patient's written consent. In that situation, you may give the requester a copy of the Part 2 regulations and state that they restrict disclosure of SUD records, but you may not affirmatively state that the regulations prohibit disclosure of the records of an identified patient. Now, granted, the net effect may be the same, but nevertheless, you can't specifically or affirmatively confirm that this patient is receiving SUD treatment or answer in a way that would indicate that they are receiving SUD treatment without the patient's consent. Now, there are certain circumstances governing the disclosure of that, when you can and can't. The general rule is you've got to have patient's written consent. There are certain circumstances where you can provide the information without the patient's written consent. Let's talk about each of those. First, but generally, you can provide disclose the SUD information as long as you have that patient's consent. The general rule is that consent must be specific to that particular use or disorder. Just some kind of a broad general consent isn't sufficient. It has to relate to that or permit that particular use or disclosure. Now, as part of the CARES Act, they made a very important change. Under the CARES Act, they've now said that you can obtain an initial consent when the patient comes in or later that allows any disclosure for purposes of treatment, payment, or healthcare operations, presumably treatment, payment, or healthcare operations as allowed by HIPAA. That consent that you obtain at that initial enrollment or that initial time that you get it applies to all future SUD disclosures by the covered entity or their business associates and the Part 2 programs to use or disclose the information for treatment, payment, or healthcare operations as to the extent permitted by HIPAA. So one consent applies forever for all the stuff, right? As long as it's a consent for treatment, payment, or healthcare operations for purposes of HIPAA. You don't need, the rule used to be that you would have to get a separate consent for each time you made that disclosure, and that's not the rule anymore. So you're going to want to make sure that you obtain that patient's consent for treatment, for use or disclosure for treatment, payment, or healthcare operations when that patient first shows up at your particular facility. Now, there are a couple of additional rules. under the CARES Act, it says that information that you disclose per that consent may be redisclosed as permitted by Hipaa. Now, what does that mean? Well, the general rule is if you send out information for purposes with the patient's consent, generally you have to send out a notice of redisclosure that prohibits redisclosure without the patient's consent or in violation of 42 CFR Part 2. This CARES Act provision seems to say that as long as the disclosure is with the patient's consent, the initial disclosure, and it's for treatment, payment, or healthcare operations, that redisclosures down the line can occur, and you may not have to send that notice of redisclosure. We're going to have to wait for the regulations implementing this CARES Act provision to see how that applies. Also, this consent for treatment, payment, or healthcare operations, that initial consent, it applies until that consent is revoked. So the patient can go ahead and revoke that consent at any time, unless to the extent that you've relied on it. So it's kind of like Hipaa. They can revoke that consent at any time, but you can rely on it until that consent is revoked. If you do make disclosures for purposes of treatment, payment, and healthcare operations, and you maintain the patient's information in the electronic health record, then you're going to need to track the disclosures that you've made of that information, even though it's for treatment, payment, and healthcare operations. That's part of the HITECH Act. We never did get the final regulations of that under Hipaa, but the CARES Act Section 3221 specifically requires that you track that information and provide an accounting of disclosure to the patient if requested. So again, that's another thing that we're going to need to monitor as these new regulations come out. So CARES Act made it easier to get a consent and just make disclosures for purposes of treatment, payment, or healthcare operations. Now note under Hipaa, you don't need the patient's express consent to use or disclose for treatment, payment, or healthcare operations. That's not the rule for 42 CFR Part 2. 42 CFR Part 2 says you still need the consent. It's just if you get that consent, one consent is good for all usage of disclosures for treatment, payment, or healthcare operations. Well, what does that consent need to contain? Well, CARES Act 3221 does not confirm the elements for an effective consent. The regulations under 42 CFR Part 2 currently do contain a bunch of requirements for effective consent. We don't know whether this is going to be carried over in the new regulations. Probably will, but we'll have to watch and see what is required for an effective consent. For an effective consent currently, under the current regulations, that consent to make disclosures may be written or electronic, but it must contain the following elements. You've got to have the patient's name. You've got to have the specific names or general designation of the Part 2 programs or entities or individuals that are authorized to make the disclosure. So it would have the name of the entity that's going to make the disclosure. It's got to explain how much and what kind of information may be disclosed, including an explicit description of the SUD information that is going to be disclosed. And it's got to list the purpose of the disclosure. Information, when you make that disclosure, you need to make sure that you limit the amount of the information so that you're only disclosing the information that's necessary to fulfill that purpose for that disclosure. In addition, you've got to identify the names of the individual or entity recipients, the entity that's going to get that information. So it's not sufficient to say we can disclose this information to anyone. You've got to identify who you're going to make that disclosure to. Now, prior to last August, the rules under 42 CFR Part 2 were pretty complicated about what kind of information you needed to get, and it generally required you to identify individuals in order to make disclosures of the information. Under these new regulations that came down in August of 2020, you don't have to get to that level of specificity. In general, you've only got to give the name of the individual or the name of the entity, not the names of the individuals of the entities, but only the name of the individual or the entity that is receiving that information. There are special rules that apply when you're going to make the disclosure. We get the consent that allow you to make the disclosure to like a health information exchange or research. In that situation, then you can give the names of the individual or entity participants, or you can give a general designation of the types of entities. So if you're going to disclose it to an HIO or an HIE, you could say that it'll go to the HIE And these are the people who will be able to access that information through the HIE, and at the very least, it has to be limited to those persons who have an ongoing treatment relationship with a patient. If you're going to use that kind of a general designation for disclosures to the HIE, the patient has a right to obtain a list of disclosures from the HIE or researcher, and we'll talk a little bit more about that later. So in addition to those other elements, an effective consent has to also contain the following. It has to contain a statement that the consent may be revoked at any time unless the Part 2 program or lawful holder has relied on it. It's got to contain an expiration date or event or condition upon which the consent will expire, and that expiration date or event cannot be no longer than necessary to serve the purpose for the consent. It's got to be signed by the patient or the person who's legally authorized to sign consents on behalf of the patient, and it has to have the date of the signature. The rules specifically say that you cannot rely on a consent that has been expired, is facially defective, meaning that it doesn't have those required elements, or is false or has been revoked. Now, in addition, if you're going to disclose information per a written consent under the current rules, you've also got to provide a notice of redisclosure. This is a notice that you give with the records, with that request for records when you're making that disclosure, when you send the records, you also have to include this notice of redisclosure, which basically informs the person who receives these records that, hey, you got to protect these records under 42 CFR Part 2. And there's two forms of the notice. The notice has to contain specific language. So the notice that used to be in there was quite long, or that still is in there. Option one is you have this very long, complex notice of redisclosure, or, and I think it was 2018, they revised it, you could simply say that 42 CFR Part 2 prohibits unauthorized disclosure of these records. So that may be a better and quicker option for you. So you have to provide this notice of redisclosure. Note that when they amended the regulations in August, that they tweaked the language of your notice of redisclosure. So you're going to want to update that in your own notices. Among other things, they tweaked it to make it clear that it's only the record that is being produced by the Part 2 entity that is subject to the redisclosure. So if you have that situation like we talked about earlier, where you disclose the record to a treating provider, and that treating provider segregates the record, the limits on redisclosure only apply to the Part 2 record, not to that treating provider's own separate record. So those are the general rules for consent. Again, the general rule is you can make the disclosure consistent with the patient's consent. That consent has to contain certain elements in order to be effective. There are a limited number of situations where you can make the disclosure without the patient's consent. A Part 2 program can communicate with others within its Part 2 program based on a need to know. So you can only disclose those within your Part 2 program to those who have a need to know. In addition, that Part 2 program can communicate with an entity with direct administrative control over the program. So if you're part of a hospital and you need to make disclosures to the administration of the hospital relating to the Part 2 program, you can go ahead and make those disclosures without getting the patient's consent. You can also make communications with a qualified service organization without the patient's consent. A qualified service organization, or a QSO, is basically one of these entities. It's kind of like a Hipaa business associate. It's one of those entities that is performing certain services on your behalf, but you have to have an agreement with that QSO, like a Hipaa business associate agreement, that limits their use or disclosure. We'll talk about that more in just a minute. You can also report to law enforcement, but only certain things. You can report crimes or threats that occurred on the program premises or that are directed against program personnel. But you've got to limit the information that you disclose to the circumstances relating to that particular incident. For example, the patient name and address, patient status, whereabouts, etc. In addition, you can report child abuse or neglect to the extent you're required by state law. But when you make that report, you can disclose information about that report, but you can't actually disclose the SUD records. They would have to come back with an appropriate subpoena plus a court order consistent with Part 2 before you could disclose that additional information. You can also disclose the information in the event of a bona fide medical emergency. You can disclose the information without the patient's consent. In August, they modified that somewhat. You can now make that disclosure if it's a bona fide medical emergency. If the patient's prior written consent cannot be obtained because there's no time or the patient's incompetent or whatever, or they modified it to also allow you to make disclosures if there's a declared national emergency or declared emergency, and because of that emergency, you can't get the information from the patient, you can't get the consent from the patient, it's otherwise a medical emergency. There's also an exception that allows you to make reports to the FDA if the health of the individual is threatened by an error in the manufacturing, labeling, or selling of the product, and you need to make that report to the FDA. In either of those cases, though, you've got to immediately following that disclosure, the Part 2 program has to document that disclosure in the patient's medical record, including the name of the medical personnel to whom the disclosure was made, their affiliation with the facility, the person making the disclosure, the date and time of the disclosure, and the nature of the emergency. Part 2 also allows permitted disclosures without the patient consent in certain circumstances involving research or an audit of a Part 2 program by a government agency, third-party payers, a QIO, or an entity with administrative control over that Part 2 program. But there are a bunch of conditions that have to be satisfied with either of those. So if you're going to fit within those, make sure you pull up the regulations and you look at those. In addition, a part of the CARES Act stated that it specifically allows disclosures to public health authorities if the information is de-identified per HIPAA. So if you de-identified, then you can go ahead and make it. I wonder if that was even necessary, since by definition, you could always go ahead and disclose information that was de-identified anyway. But be that as it may, you've now got that exception too. As I mentioned earlier, even though Part 2 would allow you to make those disclosures, any disclosure of SUD records must be limited to that information which is necessary to carry out the purpose of the disclosure that is consistent with the HIPAA minimum necessary standard. I mentioned earlier that Part 2 allows you to make disclosures to qualified service organizations without the patient's written consent to the extent that information is needed by the QSA to perform those services that are relevant to the Part 2 program. QSOs are those entities, for example, that perform data processing, collections, dosage prep, lab analyses, legal services, accounting services, or other professional medical services, medical staffing, population health management, etc. Okay, so for those entities, you can make the disclosure to those QSOs as long as they're performing these functions on behalf of the Part 2 program, and you have a written agreement between the program and the QSO. That QSO agreement, or QSOA, is again similar to HIPAA Business Associate Agreement. We'll talk about that in just a minute. So with QSOs, the QSO may redisclose its contract to its contract agents. So the QSO may have its own agents that are helping it perform the service. It can go ahead and redisclose the information that it gets pursuant to this QSO agreement to help it perform the QSO function for the Part 2 program, but it can't disclose it to other third parties, that it doesn't have that contractual relationship. Would have to have another exception under Part 2 or the patient's written consent before that QSO could disclose it to other third parties. That QSO agreement has to satisfy certain obligations. That QSO has to, or the person who receives the information has to acknowledge that it is bound by the Part 2 in receiving and storing the processing or dealing with the patient records. So you need to make sure if you're going to make disclosures to this QSO, that your QSO agreement with that QSO confirms that that QSA understands they're bound by Part 2. And if necessary, that QSO has to resist judicial proceedings to obtain access to the patient identifying information related to SUD unless an applicable exception applies. So they can't just turn it over in response to a subpoena. They've got to take appropriate steps to protect that information, and they cannot redisclose except as necessary to perform its duties. All right. Now, in contrast to QSOs, Remember, with a QSO, you don't need the patient's written consent as long as you have a QSO agreement. Separate apart from that are other entities to whom you can make disclosures with the patient's consent. So you have the patient's consent. If you make these disclosures to these other entities, then with the patient's consent, then you can go ahead and do that. They're called lawful holders. If the patient gives written consent to the disclosure for payment or healthcare operations, the recipient, that lawful holder of that information, the lawful holder of the Part 2 information, may further disclose to its contractors, subcontractors, and legal representatives to carry out such purposes if it satisfies certain requirements. So let's back up here, okay? So you've got a situation now, you want to make disclosures to another entity for purposes of treatment, payment, or for purposes of treatment or healthcare operations. You've got the patient's consent, so you can go ahead and make that disclosure to that other entity. That other entity is now a lawful holder. The new regulations will allow that lawful holder to further make disclosures to others as long as it has an agreement with those others, and that agreement has to have a written contract or other legal instrument by which the contractor is bound to comply with Part 2, just like that lawful holder. It's got to, they've got to furnish the notice of redisclosure. They've got to require the recipient to implement appropriate safeguards to protect the information. They've got to require the recipient to report the unauthorized use or disclosure or any breaches that have occurred. That lawful holder has to disclose only the minimum necessary to its contractor to allow it to redisclose that information to that contractor. And that recipient, that contractor, may only further disclose to another entity, to a contracted entity, to help them fulfill the purposes of the disclosure by the lawful holder. So it allows for kind of this trickle-down effect as long as you've got that agreement that those other persons who receive that information, that they're going to use it for appropriate purposes and that they're going to be bound by Part 2 and otherwise satisfy these requirements. Under the regulations, it used to say that you could make those disclosures for lawful holders for treatment or healthcare operations. As amended in August, the new rules specifically identify the types of payment or healthcare operations that would allow you to go ahead and make those disclosures to those lawful holders. And there is the list up there. There's a list of 18, but this is not an exhaustive list. A couple of important points. They broaden this to confirm that care coordination management is a permissible disclosure to a lawful holder. So as long as you got the patient's consent, you can make the disclosure to that other entity, to that lawful holder for purposes of care coordination, as well as these other purposes that are up there, or any other purposes that fit within the general parameters of disclosure for payment or operations. Under the new rules as amended, they will allow a Part 2 program or a lawful holder to report SUD medications that are prescribed or dispensed by a Part 2 program to a state drug monitoring program, prescription drug monitoring program. So to the extent your state requires disclosures to a drug for a prescription drug monitoring program, the new regulations would allow you to go ahead and make that disclosure, but you still have to have you still need to make sure that you comply with the requirements of that particular state, and you also need to make sure that you've got the patient's written consent. So if you know that the state requires you to make those disclosures, you want to obtain the patient's written consent as part of your, in your consent form. The regulations also allow you to make disclosures to prevent multiple enrollments, so you can make disclosures to a central registry or withdrawal management or treatment program that has like a central registry to make sure that this patient is not enrolled in multiple programs. There are certain requirements that have to be satisfied in order to be able to do that. Under the new regulations as of August, they added stuff that would allow non-Part 2 entities to actually contact a central registry and get limited information to confirm whether or not a person is part of that central registry. There are limits. Let's say a patient is referred over to your particular facility to receive treatment as part of the criminal justice system. Part 2 governs or places limits on what types of information, under what circumstances you can make disclosures concerning that patient, including disclosures to parole officers. In the interest of time, I'm not going to cover the specific scenarios dealing with application of Part 2 or how you make disclosures within or outside your organization, but I would refer you to the SAMHSA guide that I provided to you, specifically the one dealing with does Part 2 apply. It goes through different scenarios, including scenarios at a general medical facility or an integrated care setting, and talks about how Part 2 would apply. If you haven't reviewed that, I'd encourage you to go ahead and do that. It's very helpful in making sure that you comply with your Part 2 requirements. What about minors? Well, in general, if the minor may consent to their own care under state law, the minor controls the disclosure of their SUD information. So it's similar to Hipaa, right? If they can consent to their own health care, then they ought to be able to control their own substance use disorder information. That means that the program may not disclose that SUD info to the parent or guardian without the minor's consent, including disclosures to obtain payment. So perhaps unlike Hipaa, if you're a SUD program and you're treating a minor, you can't make disclosures in a way that would notify the parents of that treatment unless you've got the minor's consent. Well, that may limit your ability to get paid, right? So Part 2 confirms that the program may refuse to provide care unless that consent is given. So you make sure that the minor's giving you that consent before you go ahead and begin the treatment so that you can get paid. Now, if the minor may not consent to care under state law, you still may not disclose the minor's request for treatment to the patient, to the parent or the guardian without the minor's written consent, unless the minor lacks capacity to make rational decisions. Any consent for the disclosure to others, even in that situation where you need parental consent, where the minor's consented to make disclosures to the parents, if you're going to disclose to other third parties, it still requires consent to be signed by both the minor and the parent or guardian. Now, you may disclose certain facts to the parent or guardian without the minor's consent if that disclosure will reduce a substantial threat to the well-being of the minor or another person, or if that minor lacks capacity to make rational decisions due to their age or mental or physical condition. So, very strict requirements even for minors. Make sure that you're aware of what your state law requires for minors' consent because Part 2 generally tracks that. When it comes to other incompetent persons other than minors, if the patient has been adjudicated as incompetent, then you can get consent from the authorized person under state law who's authorized to make decisions for that individual. If the patient has not been adjudicated as incompetent but suffers from a medical condition that prevents the knowing or acting, the Part 2 program director, it really leaves you in a bit of a bind about who you go to get that information from. But it does allow the Part 2 program director to consent to the disclosure solely for purposes of obtaining third-party payment, not necessarily for other disclosures, but at least in that situation, the Part 2 program can get paid. In the case of deceased patients, the prohibition on disclosures for SUD information generally applies even to deceased patients. You may disclose certain information for vital records. For other disclosures, written consent may be given by the following persons in decreasing order of priority. If there's a personal representative under state law, you go by them. If not that, then you would have the patient's spouse. If there's no spouse, then any other responsible family member. When it comes to subpoenas and orders, just know this. Part 2 has a very complex process for disclosing information pursuant to a subpoena or court order. It's not enough, unlike Hipaa, that you simply get a subpoena signed by the judge. In order to release information pursuant to a subpoena or order, you have to have both a subpoena and you have to have a separate court order authorizing this disclosure. There is a whole process that you have to go through, or the state would have to go through in order to get that issued. Just make sure that you're aware of that before you comply with any type of an order. The CARES Act, in case there was ever any question before, specifically confirms that you cannot use SUD records in any federal or state civil, criminal, or administrative proceeding, investigation, or action unless you either have the patient's consent or court order that's issued per 42 CFR Part 2. Some programs will have identification cards. General rule here is you can't require that patient to carry an identification card when they're outside the program because there's a possibility somebody would see that and know that that person's part of a Part 2 program. You can require them to carry ID cards when they're on your premises. There are additional requirements. If you're a Part 2 program, and upon the admission of a patient into that program, then you've got to give that patient a notice of their confidentiality protections. You've got to basically summarize the federal laws and regulations, and that written summary has to contain certain information. It is set forth here on this slide. Among other things, it used to say that it was a violation of the law, the violation of Part 2 is a crime, and contained contact information. Well, in the wake of the CARES Act 3221, it is no longer a crime, so that you're probably going to need to update that notice of confidentiality protections. As part of CARES Act, they specifically charged HHS with updating its notice of privacy policies so that SUD programs have to include additional information dealing with Part 2 requirements. So watch for that. I believe that that's part of the proposed changes that are in the Hipaa rules that were issued on January 21st. Patients under Part 2, you may make a disclosure to the patient without the patient's consent, but you're not required to. On the other hand, under Hipaa, you do have an affirmative obligation to make disclosures to the patient unless you can fit within a particular exception, and those records are part of the designated record set. Under the information blocking rule, which we talked about last week, there may be additional obligations. So remember that just because Part 2 doesn't require it, it may be that another law does require it. If another law does require it, then you need to make sure that you go with the most restrictive state law. In those situations where you do make disclosures to an HIE, for example, and you use the general designation, then the patient has a right to obtain a list of disclosures of persons who've received that information, so that HIE would have to have a process in place so that it can identify those participants who received that individual. That's the obligation of the HIE, not necessarily the obligation of the Part 2 program, though. Part 2 does require Part 2 programs to take appropriate administrative, physical, and technical safeguards to protect the SUD information, similar to Hipaa, but not as extensive as Hipaa. But hey, your Part 2 program, if you're a Part 2 program, you probably have to comply with Hipaa anyway, so you need to make sure that you comply with that. Part 2 has specific limits and requirements for disposing of Part 2 records. If you can discontinue your operations, or if your operations are taken over by another entity, you can't just transfer the records. You have to jump through certain hoops, at least without the patient's consent. If there is a state law that requires you to maintain the records for a certain period of time, then you can go ahead and maintain those records, or the new entity can maintain those records if you jump through certain hoops, but you can only maintain those for the certain period of time required by state law. In the commentary that accompanied the rule changes that occurred in August, SAMHSA did create some additional guidance. There may be situations where maybe one of your employees, a Part 2 program employee, is contacted by the patient on their personal device or their personal account. These disposition regulations would have potentially required that entity to destroy his own personal cell phone and the like. SAMHSA came back and said, no, that's not what we mean. They said that if a patient contacts a Part 2 program employee's personal email or cell phone account, the employee should immediately forward information to the Part 2 program through an authorized channel, delete the information that's on its own personal account, and then in the future respond only through that authorized channel. Under the CARES Act, as I mentioned, the Part 2 program is going to have to notify the individuals if there's a breach. We're going to have to watch for the guidance that comes out about this. It's probably not a huge issue, because if you had a breach under Hipaa, if you had a breach under Part 2, it was probably going to be a breach under Hipaa, so you'd have to do the breach notification anyway. But we'll have to see whether or not there are additional requirements on notice to, for example, SAMHSA, in addition to notice to HHS or the like. The CARES Act included specific anti-discrimination statutes to protect against discrimination about persons concerning their SUDs. And that is a quick summary of 42 CFR Part 2. As far as additional resources, as I mentioned, SAMHSA has a very good website. We provided you some of the fact sheets, but if you need additional information, you can go to the SAMHSA website, and they have FAQs, they have fact sheets, they have additional guidance for you. We've got additional materials on our website, including recordings of our past and future webinars. These are the webinars that are coming up over the next month or so. If you'd like to participate, by all means, let us know. You're welcome to participate. And that is it. If you have any questions, you're not the only ones. Part 2 raises a lot of questions for me, and sometimes there's just not very good answers just because it doesn't jive very well with HIPAA or the like. But if you'd have questions and would like to submit them, I'd be happy to answer those offline. Otherwise, thank you very much for your participation, and I hope you all have a good day.